Welcome to another edition of the Business and Personal Podcast, where we bring you closer to the people that you do business with. And today we're joined by Jason Smalarz. He's an attorney at Gold, Lange, Majoros, and Smalarz here in Detroit. They have 120 years combined experience. And today we're going to talk about bankruptcy versus debt consolidation and when it's the best time to do what. And I thought it was important to have somebody with that much experience and knowledge in the market. So we're really excited to have Jason on. First of all, Jason, thanks for joining us, and how you doing today?
I'm good, Ryan. Thanks, and thanks again for having me on today. I'm really excited to be here and talk about how we can help people who are struggling.
Yes, there always is a light at the end of the tunnel. So, we're not going to make this gloom and doom. We're going to try to show the positive side of what you can do for people to get out of this. And I don't want to spend a lot of time talking about COVID. I'm sure you don't. We all know that it's impacted a lot of people. There's no sense rehashing that. So let's look forward and try to think about how people can rebound out of this. And one of the first things I wanted to talk to you about is the CARES Act, and what a great thing it was to just allow people to put pause on everything. And people couldn't make their mortgage payments and several of their other obligations. And there's a lot of people probably through the whole pandemic maybe that haven't even made a mortgage payment, and everything's been held at bay. But that's not going to last forever. So what is your advice to people to prepare for when these CARES Act provisions come to an end, and what's in store for them?
Well, my advice to people out there is to be proactive. Don't be reactive, because oftentimes when you are reactive and fail to plan, sometimes things can get out of control, and the situation can be much more dire than it might have been had you taken the steps ahead of time. With the CARES Act, obviously, we're all familiar with the government stimulus money in the forms of the stimulus payments, the extended and additional unemployment benefits, the PPP loans, and all the different things that are out there to help people and businesses. But with the CARES Act, there was also a couple of very specific and very important provisions that affected bankruptcy. And the first thing that I wanted to mention was the CARES Act had an impact on Chapter 13 bankruptcies, because what it did was it did two things. One thing is that it said that if anybody gets extra money from the government, whether it's PPP, whether it's the unemployment, that those things would not count in a person's in the calculation of their income to determine the length of a possible Chapter 13 bankruptcy. So that would be extra money that people get to keep in their pockets, as opposed to potentially having to pay back to creditors in a Chapter 13 reorganization. The other part of the CARES Act that impacted Chapter 13, it really only impacted people who were already in a Chapter 13 bankruptcy when the CARES Act was enacted. So if you hadn't filed bankruptcy by that point, it didn't really apply to you. But for people who are in a Chapter 13 plan that's been confirmed, normally under the bankruptcy code, you're in that plan for 3 to 5 years. Well, the CARES Act said, hey, we understand that people are struggling, people are losing jobs. So what it allowed you to do was to, one, pause your plan payments temporarily if you weren't, if you lost your job or experiencing COVID hardships. But it also allowed debtors to extend their plan up to 7 years. So that could really be a huge benefit for a lot of people, because it could allow you to stretch your payments out over longer, which would potentially allow you to reduce your monthly payment going forward. Also, people who were struggling to complete their plans even before COVID hit, basically were thrown a life preserver to try to keep their bankruptcy cases going for an additional 2 years. So those were two really big things for Chapter 13 debtors. The other provision in the CARES Act as it related to bankruptcy had to do with the new subchapter 5, Chapter 11, that also went into effect last February. And the new subchapter 5, chapter 11, bankruptcy, I know it's pretty wordy, but it was a new subset of chapter 11 bankruptcy that was enacted. And the whole idea was to streamline the chapter 11 process for smaller businesses. One, to make it more cost effective for them to file a chapter 11 bankruptcy, and two, to ease up on some of the restrictions and some of the barriers that exist in chapter 11 to make it easier to confirm a plan. Because one thing that a lot of chapter 11 debtors prior to the subchapter 5, especially with small businesses, they were just facing these huge obstacles that made it very, very difficult to confirm a chapter 11 plan. And then they would find themselves in a chapter 7 liquidation, which is, not good. So the subchapter 5, chapter 11 that went into effect last year had a cap. So to be eligible as a business to file this type of bankruptcy, or an individual could file this type of bankruptcy too, but there was a cap. There was a debt limit of about $2.7 million, and that was total debt. The CARES Act basically tripled that amount and increased the debt limit to $7.5 million. So it made a lot more businesses eligible for this subchapter 5, chapter 11 that otherwise wouldn't have been. As a matter of fact, I'm involved in a chapter 11 case right now where I represent the debtor, and the debtor squarely fit into that peg. The business would have had way too much debt for the subchapter 5 before the CARES Act. But with the CARES Act, this debtor qualified for subchapter 5, and it's going to make it incredibly easier for this debtor to get a plan approved than they would have before the CARES Act. So those are some really big, important things that people out there need to know about the CARES Act.
And before we started recording, you talked about a deadline with the CARES Act. It continues to move a little bit, so it's possible it could get pushed back again. But right now, as it stands, what is the end of the CARES Act set for?
So right now, the bankruptcy provisions that I just mentioned for the CARES Act are set to expire on March 26th. So this is more for the small businesses. But if you're in that, if you're over 2.7 million but under 7.5, you've got about 6 more weeks to file a chapter 11 under the subchapter 5, because like I said, it expires on March 26th. For chapter 13 debtors, like I said, if you're in a confirmed plan and you were confirmed at the time the CARES Act went into effect, and you're thinking about taking your plan out to 7 years, you've got a couple more weeks to do that, because once the CARES Act bankruptcy provisions expire, that's it. We've not heard any indication whether or not Congress is planning on extending that or not. So right now we're acting as if it's going to end on the 26th of March.
So take me through an example of an individual maybe that has not made a single mortgage payment since, say, last March when the pandemic hit, and the CARES Act expires, and they do nothing. They don't prepare ahead of time for what's coming. They just assume things are going to pick back up where they were. What will that type of individual be facing at that point?
Well, they could be facing a lot of problems. If somebody is in a Chapter 13 plan, and whether they're making their mortgage payment through the plan or they're making their mortgage payment directly, regardless of which situation they find themselves in, if they haven't made a mortgage payment in 6, 8, 9, 10 months, maybe they have a forbearance. But what happens is that when your plan expires at the end of this 60 months, or we'll say 60 months for the sake of this example, if you're in this 60-month plan and you've not extended it out, your plan expires at the end of the 60 months, and now you've got missed mortgage payments post petition. Well, what can happen is at the end of the case, the bankruptcy trustee sends out a notice to all of your creditors, and the trustee says, hey, we believe this debtor has completed their plan payments and is eligible for a discharge. And it gives the creditors an opportunity to object to that notice and say, hey, no, we haven't been paid what we were supposed to be paid. Now you've got a debtor whose 60-month plan has expired. They've missed this window to extend their plan, so now they can't extend their plan beyond 60 months. And you've got a mortgage company who comes along and says, hey, Tim Smith hasn't paid me the mortgage payment for the last 10 months. We need to get this money or Tim can't get a discharge. Well, now all of a sudden, Mr. Smith may not have that kind of money and can't get caught up on the mortgage. So Mr. Smith may find himself with his case having been dismissed. So, he'll have paid into a bankruptcy plan for 5 years, and then his case gets dismissed because he wasn't able to catch up on his mortgage. Now, there are some ways around that, but that is the prime example of a really bad outcome.
What about an individual, though, that maybe was in pretty good credit and financial standing, was not in a bankruptcy at all, but has not been making mortgage payments at this time, and now is facing the prospect of a foreclosure or bankruptcy? Correct me if I'm wrong, but the banks have not been sending foreclosure notices in this period of time, right? Is there a moratorium on that still?
Right. So there's a moratorium right now on foreclosures with any mortgage that's backed by Freddie Mac or Fannie Mae. So that moratorium is in effect, and I believe the Biden administration just extended that moratorium through the end of this month, and I believe they're probably going to extend it again until the end of March. It seems like they're doing that on a month-by-month basis. But to answer your question, if you have somebody who's not in a bankruptcy and they haven't made their mortgage payment for, let's say, 10 months, maybe they've been on a forbearance plan. The forbearance plan is going to come to an end at some point. And if the individual wasn't able to make their mortgage payment for 10 months, it seems more likely than not that they won't have the kind of cash laying around to bring the mortgage current. So at that point, they're faced with basically two options. If the mortgage company is demanding payment, one is to ask for a mortgage modification, to redo your mortgage, and that could work, but that process can take some time because we all know banks don't work at normal pace, and so it can take some time. And while that process is going on, there's no guarantee that the bank's going to allow you to continue to not make payments. So or exercise their rights to potentially foreclose. So there is that. The other option that people could possibly have is to file a Chapter 13 bankruptcy, because a Chapter 13 bankruptcy would put an immediate halt on any collection or foreclosure efforts. You have what's called the automatic stay protection. And you could do a Chapter 13 bankruptcy plan where you catch up on all of those missed payments over time. And there's a mechanism inside the bankruptcy to ask for and negotiate a loan modification. So what's really nice with the Chapter 13 is we could still work on getting you a loan modification, but you've also got the protection of the automatic stay, and you don't have to go to bed at night worrying about a foreclosure notice being posted to your front door.
I have to think there's a ton of people that have fallen into that bucket there. And I think the simple message is don't try to figure it out on your own. There's so many moving pieces right now. But there are so many options out there that they should reach out to a firm like yours and figure out what their best move is. Try to be proactive on it. And the other thing I'm thinking too, so, you have people at home that are now lining up all their debts, trying to figure out what their best move is. Could you maybe touch on, you don't have to go through all of them, but some debts that definitely could be included in a bankruptcy and some that cannot. So as people are going through their list, they know what they can discharge and what they won't be able to.
Sure. Well, you can certainly get rid of credit card debt in a bankruptcy. If you've had any sort of repossessions or foreclosures and creditor says you still owe them money, you can get rid of that. You can get rid of medical bills in a bankruptcy. And believe it or not, there are some tax debts that you can get rid of in bankruptcy. They have to meet some very specific requirements, but if they do meet the requirements, you can get rid of some tax debt. But those are the primary things, most of the consumer debts. Similarly, if you had a business that maybe has failed in the past year due to the COVID and all the things that are going on, and maybe perhaps some of the business creditors are coming after you, or you had a personal guarantee on some business debt, or you personally signed on the lease, you can certainly get rid of all those debts in a bankruptcy as well.
And there's also debt consolidation too as an option. You may not have to go right into bankruptcy. So what's usually the threshold that you look at where you suggest debt consolidation versus a bankruptcy?
Well, as a kind of a general threshold, if you're considering a bankruptcy, and let's say your debt is less than, let's say, $10,000 or $15,000, it might be to your benefit to consider a debt consolidation versus a bankruptcy. Bankruptcy is obviously it hurts your credit, and it can stay on your credit for up to 10 years. But also, it's important to keep in mind if somebody files a Chapter 7 bankruptcy, they can't do another one for 8 years. If somebody files a Chapter 13 bankruptcy, they can't do another one and they complete the plan and get a discharge. They can't do another one for 4 years, which typically doesn't matter because you're in Chapter 13 for a long time. But in any event, there are time restrictions. So I've told people in the past, if you file a Chapter 7 bankruptcy and you discharge, $10,000 of credit card debt, what happens in 3 years if you're in a catastrophic accident and all of a sudden you've got hundreds of thousands of dollars of medical bills and you can't file bankruptcy, or at least you can't file Chapter 7 bankruptcy and eliminate all of the debt. So sometimes it makes sense to save your bankruptcy for a rainy day, a really rainy day. But usually about $10,000 is kind of the threshold where you should probably consider a debt consolidation.
And then what about the most important assets such as a home and automobiles and such? Those can be salvaged through a bankruptcy. How do people go about doing that?
Right. Well, obviously, yeah. I mean, most of our largest assets are our homes. And when you're talking about bankruptcy in your home, there's a lot of things that we have to look at. I mean, the most important thing to look at is, how much equity is in the home. How is the home titled? Is it just in one person's name? If the person's married, is it in both spouses' names? Because all of those factors will play into, the type of bankruptcy that would best suit you and how we would advise you to move forward. Because really, I think what people need to understand is bankruptcy is very, very specific to each individual's situation. There is no one size fits all bankruptcy. It's not cookie cutter. It's very specific to your situation, your assets, your debts, your income, all these factors. It's almost like an algebraic formula, and you have to plug in all these variables and kind of see what the outcome is. But typically, if a house is in two spouses' names, right, and those spouses do not have any joint unsecured debt like credit cards, medical bills, things like that, for the most part, in that situation, a house would be perfectly safe in a bankruptcy. If it's not titled that way and there's a significant amount of equity, then we put people in Chapter 13 bankruptcies, because in those types of bankruptcies, you get to keep all of your assets. And then in exchange for that, you pay money back to your creditors over time.
And what is the timeline right now from filing to completion on a bankruptcy? I know 13 is going to be longer than a 7 just because of the repayment plan, but has COVID changed the timeline at all, or is it still pretty much the same as it's been?
Well, thankfully, and I give a lot of credit to just everybody in the bankruptcy bar, the court, the trustees, all the attorneys, everybody, debtors, attorneys, creditors, because everybody's done a really, really great job in adjusting to these trying times. And really, the bankruptcy process has not really been stalled or delayed. I mean, we're doing everything remotely now, so all of our hearings and meetings are being conducted either over the phone or via some sort of Zoom or other video conferencing. So we've done a really good job maintaining our timelines. If somebody files a Chapter 7 bankruptcy, usually from the time they file, it's about 90 days until they get their discharge, okay? Chapter 13 bankruptcy, as you mentioned, is very different. Usually it's 60 to 90 days from the time you file until the time that your plan gets confirmed. And then that can be extended out if there are mitigating situations or mitigating factors. But then once your plan's confirmed, then your clock starts. And if you're in a 36-month plan, your clock starts at confirmation. Same with a 60-month plan, you know, your 3 to 5 years starts when your plan's confirmed. You know, same thing with Chapter 11. The timeline hasn't really changed due to COVID. I talked earlier about the new subchapter 5, and what's nice about that is the court has really streamlined the process time-wise. Usually in a regular Chapter 11, you could have up to 6 months before you have to file a plan. Now with the new subchapter 5, it's 90 days, and they want a plan filed. And you can ask the court for more time, but they want to keep you on a pretty strict schedule to kind of get this case pushed through.
And I can imagine what a relief it must be for people when you start, just even starting that process and starting to see that light at the end of the tunnel and project when you're going to be out of that. And that's got to be a good feeling for you to help people get to that point. You've shared a couple success stories with me, but maybe if you could just share one that really sticks out to you where you help someone out in a tough spot.
Well, sure. And that's a great point. You know, people come to me and they're, you know, usually in dire straits. And I mean, I could think of hundreds of examples where just after my first consultation with somebody, they tell me that they feel better, that they feel like a weight's been lifted off their shoulders. I've had people call me a couple of days after a meeting to say that they've been able to finally sleep at night. So yeah, I mean, just to, you know, be able to give people information and peace of mind, it's a really good feeling, because nobody, you know, I have a client who calls me the oncologist of lawyers because nobody comes to me under good circumstances. So, you know, it is a nice feeling to know that I can give people some peace of mind. A success story that really sticks out, and this was some years ago, but I had a doctor, she and her husband, who, you know, were fairly successful, found themselves in a really nasty situation with some litigation and some other things, and were really in a bad way financially. So, you know, we put them in a bankruptcy, and there were some complex issues in the case that we were able to work through with them and help them out. And, you know, they got through the bankruptcy, they got their discharge, got rid of a ton of debt, and, you know, have since, you know, my client, she has since gone on to work at some hospitals around the country, and she's making a ton of money. She's got perfect credit, and she still calls me once a year to say thank you. So it was a very good success story, and there's lots of stories like that.
Yeah, so hopefully I can help you create some more success stories here through the information we put out in this podcast. What is the easiest way for people to reach out to you for a consultation? Because as we've established, don't try to figure this stuff out on your own. Go to the experts that can map out a plan for you. And how do they start that with you?
Well, the easiest way is you can either call me or you can go to my firm's website. My direct line is 248-462-7698. Or if you want to visit our website, it's www.glmspc.com. Or, I'm sorry. Our website is www.glmpclaw.com.
Got it. So, and then people, people can schedule appointments online with you?
Yeah, we can go on, they can go on our website and they can schedule appointments right through there.
Yeah, I like GLM or something like that a lot better because your name, it's easy to butcher your name. You got a lot going on
Yeah,
there.
yeah, glmpclaw.com.
glmpclaw.com. Very good. Well, hey, Jason, I'm sorry, you have one more thing to share?
Oh, no, I was just gonna say that we're flexible. We can meet, we're happy to meet with people in person. We're happy to, do a consultation over the phone. We certainly understand people's concerns. So, whatever suits you, we're willing to do it.
Yeah, I guess we didn't touch on that, but I assume you'll do virtual consultations in this COVID era, at least as a starting point.
Oh, 100%, absolutely.
Very good. All right. Well, Jason, thanks again. All kinds of great information. Hopefully we can help some people out here on the road to recovery. There is light at the end of the tunnel.
Absolutely, there sure is. We just got to take the first step and seek out help, and we're here to help.
All right. Thanks so much.
Thank you very much, Ryan. Have a great day.